Okay, good evening, ladies and gentlemen. On behalf of the International Relations Committee of the Bar Association of Sri Lanka, I warmly welcome you all to the first webinar on international investment arbitration organized by the International Relations Committee of the Bar Association of Sri Lanka. So today's webinar is indeed a very special one, as we are joined by a very eminent panel of speakers from the international arbitration arena. So in order of preference, we have with us Ms. Olga Boltenko, an investment and trade lawyer with over a decade of experience in public international law and investor-state dispute resolution. She has acted as the legal counsel in investor-state disputes under the auspices of the Permanent Court of Arbitration, the ICSID, the SEC, the ICC, and LCIA, the London Court of International Arbitration, and also HKIAC, the Hong Kong International Arbitration Center. And as arbitral secretary in dozens of commercial disputes in a wide array of industries, including oil and gas, infrastructure, construction, telecommunication, pharmaceuticals, and so on and so forth across Asia and beyond. Ms. Boltenko teaches Master of Laws degree in arbitration and ADR with a focus on belt and road investment law and initiative at the University of Hong Kong. She is listed as an arbitrator on the HKIAC, SIAC, that is the Singaporean Arbitration Court, AIAC, CIETAC, and RSPP. That stands for Russian Union of Industrialists and Entrepreneurs Panel of Arbitrators. And she sits as an arbitrator on Russia and Asia related commercial disputes. We are yet to see her first-hand experience with Russia, mainland China, and Hong Kong, a plethora of areas. Then, of course, we have with us today Professor Srilal Pereira, a retired adjunct professor of law from the Washington College of Law from the American University, Washington, D.C., where he taught a course on international law of foreign investment and conducted an advanced research seminar in international investment law from the year 2000 to 2018. That's a long time, Doctor. Professor Srilal is also a Fulbright Senior Specialist in Law and has served as Chief Counsel of the Multilateral Investment Guarantee Agency, which is also known as MEGA of the World Bank Group, until his retirement in 2010. He also served as legal counsel as the Iran United States Claims Tribunal in The Hague from 1986 to 1989. He is on the panel of arbitrators and conciliators of the International Center for Settlement of Investment Disputes, which is referred to as ICSID. And he's also a member of the panel of arbitrators of Thailand Arbitration Center. Professor Srilal is also an alumnus of Faculty of Law from University of Colombo and has completed his attorneys at Sri Lanka Law College. So today's session, last but not the least, will be moderated by our very own Dr. Asanga Gunawansa. Dr. Gunawansa is also the chairman of the International Relations Committee of the Bar Association of Sri Lanka, and he counts more than 25 years of legal practice, and his practice areas are particularly focused on construction and commercial law related litigation and arbitration. He holds a PhD from the National University of Singapore and LLM from University of Warwick on international commercial arbitration. Dr. Gunawansa is currently the chairman of the Sri Lanka International Arbitration Center and is also a member of the arbitral panels of Asian International Arbitration Center, Thai Arbitration Center, and the SAARC Arbitration Council. He is also currently the lead counsel of Colombo Law Alliance, a law chamber specializing in commercial arbitration and litigation. So with that brief introduction, let me hand over the proceedings tonight to Dr. Asanga Gunawansa to commence and continue this webinar. Over to you, Doctor. Thank you.
Thank you very much, Janak, for that very generous introduction. And I would like to give a warm welcome to both Professor Srilal and Olga. We have had both of you previously speaking in Sri Lanka to our audiences, and this is the first time that both of you are joining us, in the form of a webinar. So thank you very much for finding the time. And I would also like to thank all the participants. We have over 60 participants attending at the moment, and I think the numbers will increase as we go on. And for the benefit of the participants, as all of you know, multilateral as well as bilateral investment agreements typically allow foreign investors to enforce their treaty rights through international arbitration, which is popularly known as investor-state arbitration. Now, despite having such a forum, in every specific international commercial contract or investment contracts, you will again find arbitration clauses included. So in this background, when there's a dispute, there are choices that have to be made, by the parties involved. That is whether they are going before an investment arbitration forum, whether they are going for a contractual arbitration forum, or whether they should do both. And also there are choices in drafting these arbitration clauses as well. So we have Professor Srilal and Olga to speak on these issues today. And let's listen to them, and then I'll join both of them towards the latter part of today's session to put certain questions to them and seek certain clarifications from them. And if the participants have any questions, feel free to send them to us, and then we will screen those questions, and based on relevancy, we can put it to the two speakers. Thank you very much, and over to you, Olga.
Thank you, Dr. Asanta, and thank you, Janaka, also for the introduction. Thank you also to the team, the Sri Lankan Bar Association, for organizing this series of webinars. It is always such an intellectual pleasure to collaborate with Sri Lankan jurists, especially when it comes to matters of investment law and dispute resolution, given that Sri Lanka has such a long-standing tradition of thought leadership in investment law and dispute resolution, of course, with Justice Veeramontri and Professor Sornaraja and Professor Srilal and other distinguished professionals. I should also say a little thank you to the participants, to those who joined the webinar. It's really quite impressive for all of us to get together in such formats. I remember the last time we gathered was, in fact, in person in Colombo, and that was a very productive session. As Dr. Asanta mentioned, my topic will be somewhat of an everyday commercial reality for commercial and investment lawyers negotiating commercial contracts or investment arrangements with foreign parties. And that's somewhat different from what Professor Srilal is going to cover later on in this webinar, because Professor Srilal is going to go into the substantive issues of investment law, and I would rather deal with the one of the first steps on the way to arbitration or litigation in domestic courts that has something to do with foreign projects that would have generated investment disputes or commercial disputes. And my presentation is going to, I've been asked to cover two main areas, and that's selecting the forum for resolving disputes, meaning specifically whether that's going to be litigation in domestic courts or arbitration, and if that's arbitration, then what exactly will be the forum for arbitration, more specifically the administering institution such as the ICC, or which is more relevant to my practice in Hong Kong, the Hong Kong International Arbitration Center, or which is one of the most preferred choices, I think, for Sri Lankan parties, the Singapore International Arbitration Center, and a number of others. So that will be the first part of my discussion, and I welcome questions from the audience and also from the panelists as well. And the second part is going to be around selecting, or rather negotiating, a legal seat for resolving a dispute, and that would essentially mean selecting a set of courts that would have supervisory power of arbitral proceedings that would arise as a result of investment activities. And now with that perhaps lengthy introduction, I would also like to mention that specifically for the Sri Lankan legal landscape, it's important to understand how the Chinese investors view these processes and what their preferences are, in particular given the important presence of Chinese investors in the Sri Lankan investment landscape. And I'm not even talking about the port operators, but also about real estate, construction projects, infrastructure projects, and a number of others. And with that, in fact, with that consideration in mind, the Hong Kong University last year has designed a master degree program that is specifically dedicated to China-backed project finance and Belt and Road investment law that covers not only investment law and pure issues of investment law such as umbrella clauses or investor-state dispute resolution, but focuses more on contract negotiation, financing and structuring Chinese projects in Belt and Road jurisdictions, including Sri Lanka. And in fact, having completed the semester, I must say that our final assignment was a case study of the Hambantota port project in Sri Lanka. So we got some very interesting feedback from the students. And then back to the sort of this dichotomy, substantive investment law and the initial steps, meaning negotiating dispute resolution clauses and agreeing on the forum and the legal seat of the proceedings. I must say that this is equally important for sort of one-off commercial transactions between foreign parties, such as a Chinese party and a Sri Lankan party, but that's also important for, of course, Belt and Road investment processes where the parties would not only have one contract, but rather they would have a set of contractual arrangements, including the investment agreement, the sort of framework investment agreement, but also the underlying, perhaps, construction contract, but also financial arrangements. And something that's probably dear to Professor Shrilal's heart, political risk insurance that would have been for Chinese clients of mine would have been provided by Sinosure and very rarely by MIGA, given the current landscape. So each one of these arrangements would have their own dispute resolution clauses, and ideally and hopefully those clauses would be compatible such that a dispute that arises on the basis of the same facts and sort of same law can be resolved in one forum rather than being the creation of several sets of proceedings, including litigation, arbitration, and a number of other processes. But each one of these arrangements would have a dispute resolution clause that would select the seat, the legal seat, if we are in the arbitration landscape, but also the forum, meaning essentially either litigation in local courts or arbitration under the particular set of rules or the auspices of an arbitral institution. And I'll start with the seat. The legal seat of the arbitration is important for a number of reasons. Essentially, the legal seat of the arbitration determines the destiny of the arbitral proceedings, because by agreeing on the legal seat of the dispute, the parties select a set of courts that would have important supervisory power over the arbitral proceedings, including the sort of nuclear power of setting aside an arbitral award. And that means that it's only at the courts of the seat that the award can be set aside, while the enforcement can take place wherever the enforcing party can identify the assets. And now, but of course, there are other important powers on supervisory courts that would depend on the local arbitral legislation. And for the majority of countries in Asia, that would be ancestral model law. So that wouldn't necessarily just only be set aside powers, but also the sort of jurisdictional challenges to the preliminary findings by the tribunals on jurisdiction, but also powers to finalize the constitution of the arbitral tribunal if the arbitral rules haven't been agreed upon, and a number of other important powers. Now, having said that, given the importance of selecting the seat for arbitral proceedings, the underlying assumption for the majority of China-Sri Lanka transactions would include considerations of either Hong Kong or Singapore. And with that in mind, I'm sure that a number of you would have attended conferences where you would have representatives of Hong Kong as a jurisdiction and Singapore as a jurisdiction extolling the virtues of their respective jurisdictions in terms of why seating their disputes there would be preferable. And it can be very, it's easy to sort of get lost in that very intensive marketing campaign. And I think it's important for commercial lawyers when they're negotiating dispute resolution clause and selecting a legal seat. It's important for commercial lawyers to know the difference between these two jurisdictions, Hong Kong and Singapore, and how those differences match the dispute that might potentially arise as a result of the transaction that they're working on. You'd see there are a number of guiding principles that corporate lawyers use or resort to when they negotiate those clauses. But of course, the best choice would be to talk to your dispute resolution lawyers and see what jurisdiction, what seat would be preferable. But if that is not available, then there are a number of guidelines that corporate lawyers can use, such as, for example, a couple of years ago, Global Arbitration Review and Chartered Institute of Arbitrators put together 10 items that need to be looked at when the parties select a seat. Those 10 items are now named the London Principles. And so these 10 items are actually quite useful. And if you look at one of them and see what is the situation in Hong Kong and Singapore or any other jurisdiction that you're considering, then it makes the choice somewhat easier for the parties. And it also makes it easier to negotiate with the other side when you have a reasonable approach as to why a particular jurisdiction would be a better seat. And I would name, these principles, London Principles, are available online, so they're easily accessible, but I'll name just a few. The first one, of course, would be legal framework in each particular jurisdiction. For example, in Hong Kong, the legal framework for arbitration is ancestral model law based, and it's the Hong Kong Arbitration Ordinance. It's very transparent. It's available in the English language. There's judiciary that has a decade, if not more, of experience interpreting and applying the Hong Kong Arbitration Ordinance to set aside applications and other arbitration-related matters. So that's one important legal framework consideration. Now, Singapore is also an ancestral-based jurisdiction, and it's very easy to say, well, these are almost identical jurisdictions, so it doesn't really, matter which one we choose, and it's all sort of a negotiation principle. But there are important differences. For example, under the Hong Kong Arbitration Ordinance.
Thanks.
Sorry. Under the Hong Kong Arbitration Ordinance, the preliminary finding of an arbitral tribunal on jurisdiction, which is a positive finding, where the tribunal would say, yes, we have jurisdiction over the dispute, can be challenged in the Hong Kong courts, and that challenge should be decided by the Hong Kong courts, and the decision is final and not subject to appeal. So that decision of the first instance court cannot be brought to the Hong Kong Court of Final Appeal. So you really only have one go. Whereas in Singapore, the Singapore International Arbitration Act allows the parties to challenge preliminary findings of the tribunals, both as to them having their jurisdiction, asserting their jurisdiction, and also the negative findings saying that they have no jurisdiction. So that might be important when a party, say a claimant, is thinking, well, if I've got a positive finding by the tribunal that they have jurisdiction, I don't want to be involved in litigation that would go on for a number of years, where the courts of first instance would have to decide whether that decision to assert jurisdiction is right or not. So you might want to consider that. So that's legal framework, and all of that might be getting a bit complex, but this is to say that each jurisdiction, even though it might be ancestral law based, will have their own differences, and it's important to consider those differences when selecting or agreeing on the legal seat. So it's very easy to fall victim to the conference speeches about how wonderful the Exchange Square in Hong Kong is, or Maxwell chambers in Singapore, but that's not what probably matter for selecting the seat. Then independent judiciary would be the second important consideration when it comes to selecting the seat. And of course, this you would have read in the news or watched on BBC a number of considerations that come to the independence of Hong Kong judiciary as opposed to what is happening in Singapore. The Hong Kong judiciary is, in my experience as a practitioner, having been based in Hong Kong for over 7 years, that the judiciary here is not subject to influence from other jurisdictions, and it's rather independent. It also includes in the highest court, in the Hong Kong Court of Final Appeal, justices from other common law jurisdictions that are not Hong Kong judges, such as judiciary from Canada, Australia, New Zealand, and the UK. And we have testimony from those judges that they wouldn't be sitting in the Hong Kong Court of Final Appeal if they were subjected to influence from other jurisdictions. So when it comes to Hong Kong, it's of course also easy to fall victim to mass media and think that jurisdiction is under siege, but it's not, in my experience as a Hong Kong practitioner. Then of course the availability of local pool of practitioners in each particular jurisdiction, whether there are arbitration practitioners, litigation practitioners that are available in Hong Kong, Singapore, and other jurisdictions that can work on a particular matter, set aside application, or other applications with the courts. And with that comes in mind the other criteria, which is whether counsel in the arbitration can be admitted or have an ad hoc admission to present a case, a set-aside application, for example, before the local courts. And now both Hong Kong and Singapore have ad hoc admission rules where the judiciary would consider the merits of an application of an overseas counsel to represent a party before local courts when it comes to arbitration-related matters. In Singapore, the judiciary applies a less flexible approach when it comes to admitting foreign counsel. More specifically, they will look at the considerations as to whether local counsel in Singapore would have the expertise to present the set-aside application. And if local counsel do have that expertise, it's unlikely that foreign counsel will be admitted. In Hong Kong, though, the judiciary takes a somewhat more flexible approach where they would take into account the fact whether a foreign counsel would have represented a party in the arbitration proceedings. With that in mind, they would think, well, that foreign counsel would have been working on the case for quite a while and would be useful to the court in terms of presenting a set-aside application or other applications. So it's easier for a foreign counsel to get admitted, to get ad hoc admission in before Hong Kong courts. And then, of course, the travel arrangements were once important considerations, the ease of travel to and from jurisdiction for the hearings and other matters, of course, were now all under travel restrictions, including us in Hong Kong, but also in Sri Lanka, and the same in Singapore. So that's sort of not a consideration. But when that is lifted, both Hong Kong and Singapore have very convenient venues for hearings, for travel arrangements. The only concern would be availability of visa preferences for those who are coming for arbitration hearings, and how easy it is to get into a particular jurisdiction, and whether there's a visa-free regime for counsel coming for hearings, for witnesses, for experts coming for hearings. For certain nationals, it might be, for myself being a Russian national, it is quite difficult to get the visa to travel to Singapore, and it takes a while to be at the consulate, or in Hong Kong there's visa on arrival, so that might be a consideration. And so a number of other issues that sort of constitute these 10 London principles that are quite handy for commercial counsel when they're deciding what legal seat to agree on for resolution of their disputes. And that is when we are in either commercial environment, a commercial transaction environment, or even in the investor-state disputes environment that is outside of the World Bank auspices. And of course, when we are in the World Bank context, when the dispute is to be submitted to the ICSID for resolution, then these considerations do not matter at all. And that is because ICSID arbitrations are, they have no legal seat, and more courts would have supervisory power over ICSID arbitrations. The ICSID convention itself would contains a number of very limited grounds on which an ICSID award can be annulled. So an administrative council would put together an ad hoc annulment committee, and the committee will decide the annulment application. But no courts in the World Bank context would have that important supervisory power, or any supervisory power, when it comes to arbitral proceedings. So I think that's more relevant to Professor Shrilal's presentation later today, when he'll talk about umbrella clauses. But the selection of the seat will be more relevant for commercial disputes, and those investor-state disputes that are not ICSID, that are not subject to resolution within the World Bank auspices. And now, when it comes to the forum selection and the forum, when it comes to the seat selection, we're already on the assumption that that we're in the arbitration context, that the host state or the other party, investment party, has agreed to arbitration, to sort of taking the dispute from the ambit of the local courts and bringing the dispute before international tribunal, international arbitral tribunal. In a number of situations, specifically when it comes to Belt and Road projects, large strategic infrastructure projects for Chinese clients, they don't even have that option, because the host states would say, no, this is a strategically important infrastructure project, such as, for example, a large container port terminal, and therefore the dispute cannot be submitted to arbitration. The dispute would have to be resolved within that jurisdiction in the local courts. And oftentimes those would be state procurement procedures through which Chinese investors and other investors would have to go through. So they wouldn't even have a say as to whether they'd rather have arbitration than litigation in local courts. So at times investors, Chinese investors, would have no choice, and they would have to deal with the local court litigation provision in the template sort of dispute resolution clause in an investment agreement. And that is where the bilateral investment treaties come into play. And that is where specifically the umbrella clauses in those treaties come into play, because as Professor Shrilal would mention later, the umbrella clauses would allow the breach of the contract to be elevated to the breach of the treaty. And then of course you would have to deal with provision, the local courts DR provision in the contract versus the investor-state dispute resolution provision in the treaty. With that, I will take a 1 second break because I need to plug my laptop into the electric plug. Otherwise, I'll disappear. I apologize for that. Just 1 second. I'll find the electric plug. All right, done. And we're back. So that concludes the largest part of my presentation that had to do with selecting the seat of the proceedings. And I'll take just a couple of minutes to cover the forum. And the forum in that context would mean when we're in the when we've gone through the the local courts provisions, the forum would mean in the arbitration context what set of arbitral rules and what arbitral institution the parties would agree upon in their dispute resolution clause. And there, of course, you have a plethora of choices. The Hong Kong International Arbitration Center as an administering institution with its own set of rules. The Singapore International Arbitration Center, of course, with very contemporary set of rules, as well as the International Chamber of Commerce. For Chinese parties, traditionally the Stockholm Chamber of Commerce was a preferred choice for a while. And then a number of other arbitral centers with their own sets of rules. And I understand that for commercial lawyers, corporate lawyers who negotiate these transactions, it's not always easy to navigate in the differences between all of these arbitral institutions, comparing the rules and what rules would be better suited for a particular dispute. And indeed, a lot of these rules look or seem identical, but that's always quite tricky because some of the rules are different. For example, until the latest amendments, the SAIC arbitration rules did not contain joinder, multi-party and multi-contract provisions, which meant that for a large-scale transaction that would involve a number of contractual arrangements, unless the parties would sort of copy-paste their dispute resolution clauses and they would be compatible, and the parties would agree that all of these disputes can be resolved in one set of proceedings, it would be very difficult to consolidate. Whereas in Hong Kong, the HKC arbitration rules have had consolidation and joinder provisions for quite a while. But now, of course, the SAIC since 2016, they've updated their rules and they have a rather complex 3-4 page long consolidation and joinder provisions, which can be quite difficult to navigate. So comparing those rules, but also comparing the legal seats and their legal regimes for arbitration would be a very important step for any lawyer negotiating a transaction, in particular with Chinese parties. And all of that I'm saying on the assumption that it will be very rare for a Sri Lankan party or any other foreign party to agree on a seat in the mainland China with a dispute administered by CETAC for a number of reasons. And now with that, I think it's time for me to conclude. Jannika asked me to share a war story, or at least perhaps one anecdote of negotiating legal seats and fora for resolving disputes. And I would take 1 minute to share a story, a very recent story where my team with the project finance lawyers, but also us within the investment protection department and the dispute resolution department, we represented a Chinese client, a Chinese state-owned enterprise that was building and restructuring a container port terminal in an African state. There are a number of arrangements that were being put in place, including a free economic zone arrangement and the lease agreement and the management agreement. There's a joint venture involved, so it was a rather complex negotiations process. But the host state, the lawyers negotiating the contracts on behalf of the host state, they would always say, we do not want to take these disputes out of jurisdiction of the host state, because this is a strategic infrastructure project, and our domestic law wouldn't allow us to take these disputes out of the country and bring them to London or Paris or Hong Kong or Singapore for resolution. So they insisted on their own domestic law, and the seat being, of course, first of all, they insisted on litigation in their own courts. And once we've managed to overcome that, saying that if you go for litigation in domestic courts, then the political risk insurance that we'll be able to obtain as Chinese investors will be much higher, more costly, which will change the sort of financials of the project. And if that's what you want, we can go for that, but there's a price to pay. So the decision was made to sort of move to other stage of negotiation, saying, well, we can go for arbitration, but it should be governed by our own domestic laws and should be seated in our country. And the end result, after rather vocal negotiations, was that we agreed to apply their own domestic law, but the seat was selected to be in a neutral jurisdiction where the judiciary would be experienced enough to apply another set of laws and still come up with a fair resolution of the dispute. So I think with that, I'll stop here. I know everyone's excited to hear what Professor Srilal has to say about the substance of investment law, and I'd be happy to take questions at the end.
Thank you very much, Olga, for that excellent presentation. And I'm sure our audience might have certain questions for you, and I certainly have a couple of questions for you. So I'll come back to you with that towards the after Srilal finishes. So Srilal, now you're on. So please share with us, what your views are on the topic that have been allocated to you.
Well, thank you very much, and good evening to everyone. I really want to express my gratitude and thanks to all of you for having me on this webinar on a very important topics and And thank you, Olga, for placing me with such distinguished company as Professor Veeramantri and Professor Swarnaraja. They were my mentors, and I'm in very distinguished company. Thank you very much for your very generous comments about that. And what a enlightening presentation that you made about the seat of arbitration. As Olga said, mine is a little bit complex. The subject is quite complex. It's very recent, and it brings to the fore the conflict between the application of treaty law and investment agreements. And it is very crucial and complex only because that none of the investments as we see as investments are really made in a vacuum. They are made in a complex set of investment agreements, usually investment contracts. And that brings us to a point where one has to look at what overriding bilateral investment treaty says and what investment contract really says about the transaction. So let me give you context by citing a particular arbitral decision, which was in 2003, SGS versus Pakistan. In that particular case, SG had a concession contract for pre-customs clearing with the government of Pakistan. At the end at the end of the period of the concession agreement did have a clause, and that clause was that in the event of a dispute in the concession agreement, that it would be referred to Pakistan arbitration, and the applicable law would be Pakistani law. Now, the investor suffering loss because of an early termination of the concession agreement then sought to resort to an investment treaty, a bilateral investment treaty between Pakistan and Switzerland, which had what one calls an umbrella clause. Now, the content of the umbrella clause is to state that where there is an obligation created in an investment agreement or investment contract, then the state party shall observe all of those obligations and responsibilities in that investment contract. This gave an avenue, as it was interpreted to mean, that an investor suffering a loss under a contract then could proceed to arbitration under the investment treaty, foregoing the application of the exclusive jurisdiction clause for Pakistan arbitration, and also the application of Pakistani law. The tribunal there argued, at least in the judgment, with the claimants bringing in the claim under the umbrella clause, the tribunal, the Pakistani defense was that applying the umbrella clause had the effect of elevating a simple breach of contract claim to a treaty claim under international law. So there begins the conflict of laws situation. This invocation of a treaty provision to have tribunals consider contract claims have evoked, therefore, very challenging issues for arbitral tribunals. But I must now allude to some of the fundamental differences between investment contracts and investment treaties. The key differences between an investment treaty and an investment contract are the following. In an investment treaty, such as a bilateral investment treaty, or now the new generation of bilateral investment treaties, which are called international investment agreements, to go into investment treaties, there are three elements that I need to emphasize on. Firstly, in a treaty, the two parties to the treaty are two states, not the investors, but two states. Now, in an investment agreement, of course, there are enabling provisions, which is to say that investors from state parties can invoke the treaty without having state responsibility, or the investor's national state then representing the investor. Second, the forum for dispute resolution is usually an ad hoc institutional arbitration, ad hoc or institutional arbitration. Usually in investment state arbitration, it is before, most of them are before the International Center for Settlement of Investment Disputes, which is an institutional arbitration forum under the aegis of the World Bank, as Olga referred to. So in the event of a dispute arising between an investor or one state and a state party, then that investor can then bring suit against the state party under institutional arbitration. The third is that in international treaty arbitrations, the applicable law is international law. That's very, very significant. And therefore, what are the conditions under which an international tribunal applying international law can take cognizance of a purely contractual breach that has caused a loss? And on the other hand, an investment contract, in an investment contract, the parties to an investment contract are a foreign investor and a state party. The forum for dispute resolution, unlike international tribunals, can be ad hoc or institutional arbitration forums like the ICC, the Permanent Court of International Arbitration, the London Court of International Arbitration, and the American Association of Arbitration. And more importantly, and currently, because of the relevance and the passage of arbitration rules and laws in domestic countries, whether it is Sri Lanka or China or elsewhere, there are now arbitration rules and access to arbitration under the arbitration rules of that particular country. So, and even more relevantly, the preceding areas, I mean, about 10 or 20 years ago, actually, any dispute, a contractual dispute, had to go before a court, a local court, having jurisdiction over a contract dispute. And most importantly, the applicable law is domestic law. Now I've seen a contract where an investment contract in which the party, the investor and the state party agreed to ad hoc arbitration before ICC, but the applicable law really was domestic law. And the contract was to be performed in Tanzania in a gold mining project. So it is very, very important to understand that there can be third-party forums or a forum outside of the host state, but the applicable law is really domestic law. So in that case, the applicable law was Tanzanian law. So if I can perhaps ask Pasindu, Mr. Pasindu, if you can put onto the screen a hypothetical to give you context of what I am stating. Is that a possibility? Yes, so now you can see the hypothetical here is a hypothetical in which General Electric, a power producing company, makes a $200 million investment in a power project in Sri Lanka. Now, above and beyond this, you will see that there's investment treaty, bilateral investment treaty between the United States and the government of Sri Lanka. Now, this is a hypothetical. I'm not saying that it has happened. It is a hypothetical. So it's a $200 million power project. And usually what happens is that General Electric, which is a USA incorporated company, will come into an agreement, overall agreement for the 200 million power project with the government of Sri Lanka, in which the obligation of General Electric is to establish a power plant and operating power plant, and then produce electricity, which will then be sold to the government of Sri Lanka. In addition to that, and for practical purpose, for all practical purposes, there will be what you call, if you go down, you can see there is the operating company, GE operating company, which is then incorporated in Sri Lanka. For all practical purposes, they do that. For tax purposes, for purposes also of dispute resolution, the company is incorporated, the operating company is incorporated in Colombo. And it is agreed to construct a 250 megawatt, which is large megawatt project, and sell the Ceylon, sell the power that is produced to the Ceylon Electricity Board, which is a state-owned entity or a state-controlled entity. Now, the difference is now, you can see the difference. In the bilateral investment treaty, if there is a problem that General Electric has with the government of Sri Lanka, then the government, then General Electric can come under the bed and for purposes that are treaty breaches and then proceed against the government of Sri Lanka. But that is not the only investment agreement. The other investment agreement is the most important, the 250 megawatt power purchase agreement, which lays out the responsibilities and obligations of both the GE operating company as well as the Ceylon Electricity Board, again, a state-owned entity, which then purchases the power. So that gives you generally an idea or a framework within which we have to look at this problem. So let me get back to the presentation, and I would ask that the audience take a good look at how the transaction, the real transaction can be framed. So now, as you would see, with this sort of hypothetical and within the framework of the interaction between investment agreements and bilateral investment treaties, what type of conflicts can really occur. Now, why is it that under international law, there are restrictions of taking into cognizance pure breaches of law? And this is something which has not been discussed by arbitration tribunals that really have confronted the issues between the application of domestic law or municipal law and international law. So under international law, there are some fundamental constraints as to why international tribunals or international adjudicatory bodies that are governed by international law cannot freely take into account a breach of contract. The first concept is what we all know, first fundamental concept, what we all know is something called pacta sunt servanda, which is the sanctity of contract. International forums are precluded from reviewing losses incurred under a contract breach, primarily because the terms and conditions concluded in a contract are specific to that contract under question, and no third party is permitted to interject. Second, and a decision on a dispute must be based on those terms and conditions in the contract alone, as decided by the forum selected by the two parties. Under all some circumstances, these must be given primacy, which means that if the two parties have chosen that any dispute under a contract must be resolved by the application of domestic law, that must be given primacy and not international law under a bilateral treaty. Now, there are exceptions to this principle. So the first exception is when the state party has caused a fundamental breach by an altogether independent action that can be brought within an investment treaty. So in this particular example that I have stated, for example, the government of Sri Lanka decides to expropriate the GE operating company in Colombo, Sri Lanka. And that would be a separate action from a contractual obligation. But what it does by expropriating the GE operating company is that it scuttles the power purchase agreement. And therefore, the government controls the tariff rates, for example, that need to be paid. So that would be a complete termination of the power purchase. That's the effect of the expropriation. And that then can permit the investor to go on an expropriation basis under the bilateral investment treaty rather than ask for a termination of the power purchase agreement. So that's fairly different. Now, the second exception is where the two parties have exhausted the dispute resolution remedy in the contract. For example, if the contract says the power purchase agreement says that resort must be held to the local courts, that is the district court or the appeals court that can take into account breaches of contractual obligation under its jurisdiction. So there is an obligation, therefore, under this particular power purchase agreement, if it states that for all dispute resolution, you must first then go to the local courts as decided by the two parties in the particular contract. So in both of these exceptions, investment treaties take cognizance of a dispute that can be resolved through application of treaty standards and international law. So let's proceed from there where the conflicts are. As mentioned at the beginning, serious conflicts have arisen due to what is commonly called an umbrella clause that has been included in investment treaties, in most bilateral investment treaties. A typical umbrella clause in an investment treaty reads something like this. Either contracting party in a treaty, either contracting party shall consistently guarantee the observances of commitments it has entered into with respect to the investments of investors of the other contracting party. Two early investment treaty disputes set the stage to unravel the conflicting issues that emerge out of investment agreements and investment treaties when it comes to contract breaches. SGS Pakistan, which I referred to earlier, was a concession agreement which was terminated prematurely, and therefore under the contract terms, the government of Pakistan was required to pay termination fees. This they didn't do. The investor had resort to the Pakistan-Switzerland bit, used the umbrella clause to force the tribunal, the executive tribunal there, to take into consideration losses under the termination agreement, under the concession agreement for termination. Pakistan defended its actions by stating that there was an obligation and a responsibility under the concession agreement to go to Pakistani arbitration under the Pakistan arbitration rules, and that the investor had not done. So that was the issue that was stated. And Pakistan furthermore stated that what the umbrella clause seeks to do is to elevate a mere breach of a contract into a breach of a treaty obligation, compelling the tribunal to apply treaty standards rather than the law, the standards that the domestic law, arbitral law had in mind. So there, the tribunal actually concluded and agreed with Pakistan's position, stating that if the umbrella clause was to be used to such an extent that even minor breaches of contracts could be brought before international tribunals under a bilateral investment treaty. And therefore, the tribunal concluded that the intent of the state parties could not have been that it was that an umbrella clause is so expansive as to encourage all types of breaches to come within the jurisdiction of a tribunal and discuss there, and therefore the tribunal rejected the arguments of SGS, the applicant stating that the umbrella clause really did not did not amount to the facts of the case did not amount to a point where the umbrella clause could be used under the treaty. The second case was SGS versus Philippines, the same investor, a Swiss investor, who really were experts or specialists in customs clearances. And so they too also had a concession agreement with the Philippine government in order to do customs clearances and procure any charges that on behalf of the government for custom clearance. Here, the tribunal took cognizance of the dispute resolution clauses, both in the contract, reference of any contract dispute, the courts in Philippines having the appropriate jurisdiction. So in the Philippines case too, the concession contract that was concluded by the two parties referred any dispute under the concession contract to dispute resolution in the courts, the local courts having appropriate jurisdiction. The tribunal here in SGS versus Philippines came to a different conclusion than SGS versus Pakistan. So there's a juxtaposition of the two exit tribunals. Here, indeed, the tribunal took into account that there was a contract, this was a contract dispute, but concluded that contract disputes can be taken cognizance of under the umbrella clause, but also concluded that the dispute resolution clause in the contract was very, very important to consider and should be considered, which was the dispute resolution clause in the concession agreement referring any disputes to the Philippine courts. So what the tribunal did was, having said that contract disputes can be brought before a tribunal, it nevertheless said that given the dispute resolution forum being domestic court, it stayed the tribunal proceedings and permitted stayed the tribunal proceedings and referred the matter back to the Philippines courts if SGS was to take the matter to the Philippine courts. In subsequent cases, and there are many, this whole issue of the utility of the umbrella clause. And there was one other element that SGS Philippines came out with. They came up with a general proposition which said that if there is this clause called the umbrella clause, and if it had no effect, why did the two state parties to the bilateral investment include it in any way if investors cannot get protection under the umbrella clause? So there is the French phrase called effet utile, that is the utility of a particular provision in investment treaty. And therefore, the tribunal concluded it only means that even if there were contractual obligations that have not been met by the state, that under the treaty, tribunals could take cognizance of treaty disputes. In subsequent cases, Nobel Ventures versus Romania, the tribunal concluded that contractual claims can be brought under the umbrella clause to provide the investor with an international remedy as an exception to the rules deriving from autonomy of municipal law. Also acknowledged that an umbrella clause in a bit must be effective, that is the effet utile argument, more closer to the SGS Philippines arguments than SGS versus Pakistan. In El Paso versus Argentina, another tribunal, the tribunal completely adhered to the reasoning given in SGS versus Pakistan, that contract disputes cannot be the subject matter of jurisdiction under the umbrella clause under investment treaties. But it was still critical of both SGS cases, and Nobel Ventures opted to characterize contracts that were commercial in nature and sovereign in nature. So they made a distinction between what is essentially contracts that a state concludes as commercial contracts, like buying and selling, versus sovereign contracts, where the sovereign government, for example, has contracted to collect taxes, to collect tariffs. That is essentially what the distinction that was made. And the distinction is that so they characterize what types of disputes can be, contract disputes can be brought before a tribunal under an international treaty. And what they said was, yes, where there is sovereign contracts between the sovereign and an investor, collection of taxes that was disputed, or collection of tariffs for that matter, those can be brought within the substantive elements of an umbrella clause, but not commercial contracts where the government is acting as a merchant and buying and selling goods. So a very interesting distinction that they did. So another important, and finally, there were so many cases, but I cherry picked some of the more important ones. Why it was called, the last one is Devack versus Paraguay. Considered both the SGS cases again and concluded that the umbrella clause could be read to include a contractual arrangement between the investor and the state. It emphasized the effectiveness of the umbrella clause in an investment treaty, but also agreed with the exclusive forum jurisdiction, exclusive forum selection and jurisdiction in the clause in an investment contract. So very importantly, most tribunals completely agreed that if there is a reference to the exclusive jurisdiction of local courts other than the treaty forum, then resort had to be had in terms of referring the dispute to the local courts if it has not been done. And this is very important because in the end, if it is not being done, there are two issues there. Then you're completely ignoring exclusive forum selection clause that has been agreed to by the two parties to the contract. Inasmuch as tribunals concluded and characterized that what is the purpose of an umbrella clause if it cannot be utilized, then one can also reasonably argue that what is the purpose of having exclusive forum selection jurisdiction in a contract if indeed the treaty clauses trump the contract clauses, the specific contract clauses. So if a util, or the effective utility, works both ways. That's the first part of it. The second part of it is that it also conforms with the international law principle that in the end, there is a resort to exhaustion of local remedies, and gives an avenue also to the investor that it has actually exhausted all the contractual remedies under the contract, but now has experienced a denial of justice, and therefore that converts itself into another claim under a bilateral investment treaty, maybe on the fair and equitable treaty, a fair and equitable treatment clause of a bilateral investment treaty, or in fact, the constant security given to investors for their investments. So very interesting. In all of these cases, the tribunals actually did not move forward, finding other alternative mechanisms in taking into consideration the issues involved and the losses concerned. And so there was no really reference to the applicable law, which is the most important thing in my opinion, because if the applicable law, just like the forum selection clause, is specified in the contract, it should be applied. So even if the tribunal were to conclude that, yes, under the umbrella clause, we can take into consideration contractual disputes, the important thing is that even, as I said, even if they were to do that, then they would be compelled, the tribunal would be compelled to apply the applicable law, which is almost always domestic law. It is either Tanzanian law or Sri Lankan law, as the parties agree to. So in any event, in terms of determining whether there was a loss and providing damages or asking for termination costs, if the case may be, the tribunal would have to be or would be forced to apply the contract law and not the treaty law, unless the dispute is deemed to be an expropriation of the contract or other termination, other breach of a treaty clause. Now, so there are lessons to be learned from here, and it goes exactly to where Olga was talking about. So critically important, both for the investors as well as state parties, to negotiate these agreements very carefully. So if the investors were to negotiate this contract, they must make sure that what they want is international arbitration. And that's very, very difficult to do in terms of negotiating a contract. But for state parties, it is really, really important, mostly developing countries, it is really, really important to negotiate the umbrella clause very, very, very cleverly. If the intent is to subject a contract dispute to the local courts and the application of local law, they must say in that umbrella clause that this clause does not apply to any breaches of contractual obligations under a treaty, or treaty, notwithstanding anything what the treaty states, that this contract dispute can be resolved only through resort to the particular agreement. So with that, I'll stop, and I'd love to take any questions that you might have. Thank you.
Thank you, Professor Srilal, for that thought-provoking presentation, and also Olga for your presentation. Without wasting much time, may I now invite Dr. Asanga to commence the Q&A session. There are a lot of questions that has been posed by the audience itself. We have roughly about 20 minutes more. Doctor, over to you.
Thank you very much, Janak, for that. Yes, we have a few questions. And thanks again, Srilal, for a lovely presentation and wealth of knowledge that you shared with our participants. And I'm sure, especially our young lawyers who are joining in, who have joined in, would have really benefited from that. So before we go to the questions that have been posed by the participant, Olga, I have a quick question for you, which you might be able to clarify. If you recall the famous decision by the Singapore Court of Appeal in BNA versus BNB of 2019, I think the dispute arose out of a gas takeout contract, and the governing law of the agreement said that it's governed by the law of People's Republic of China. Then there was an arbitration clause which provided that dispute shall be submitted to SIAC, but for arbitration in Shanghai. And then there was this statutory provision under Chinese law, which prohibited foreign-seated arbitration administrative institutes like SIAC from doing arbitrations in Shanghai. So in this context, the question came, what is the governing law applicable? What is the law of the seat of arbitration? Can you share some views on that, with our participants?
Yes, that's indeed sort of landmark decision when it comes to China-related arbitrations. And there's a number of issues that arise in that question and as a result of that decision. And also I think that ties to one of the questions that was asked on the in the Q&A chat as to whether ad hoc arbitration awards rendered overseas with a seat overseas outside of mainland China would be enforceable in China. I think, and me not being a PRC qualified lawyer myself, rather a Hong Kong qualified solicitor, which is a completely different legal system from the practice of my PRC colleagues in the mainland China. I think that there are a number of principles there that we need to remember. China doesn't recognize ad hoc arbitration, the validity of ad hoc arbitration agreements with a seat in the mainland China. So if the dispute is seated in the mainland China and it is administered by one of the Chinese arbitral commissions, it must have an administering institution. If the arbitration is ad hoc, the arbitration agreement would be invalid. So China doesn't recognize its own, by legislation, domestic seated ad hoc arbitrations. However, when it comes to foreign seated arbitral disputes, in particular in a seat that recognizes the validity of ad hoc arbitrations, China as a member state to the New York Convention would be under an obligation to enforce that award, unless of course there exist grounds for refusing to recognize and enforce the award under the New York Convention. And then when it comes to foreign institutions administering a China-seated dispute, then it becomes even more tricky. And there's a number of questions there. First, why would you ever want to do that? Because obviously, if you have, say, a foreign arbitral institution, SAAC, administered that is not recognized as an arbitral commission in China, with a seat in China, you are already, as a party, putting yourself at risk of that arbitration agreement being invalid. Now, there's the Hong Kong International Arbitration Center, for example, is a recognized institution in China, has an office in Shanghai. The SAAC recently also, I think, opened an office in Shanghai. So if the basic line there would be that if the dispute is seated in the mainland China, it has to comply with the Chinese arbitration law, which requires an administering institution, and when the recognized administering institution, if the dispute is seated in China. So that's some longish answer to your question. I hope that that helps.
Thank you, Olga. Olga, there's another question which I would like to put to you before I move on to Srilal, which may not be directly related to what we discussed today, but will be very useful for the practitioner. Now, one of the issues that we face is, especially when local commercial companies partner with foreign entities, as you know, in the form of joint ventures and so on, they do during the negotiation process agree to have foreign seated arbitration. But then when the arbitration processes commence, they realize that, you know, for example, if the arbitration is to be referred to ICC arbitration or SIAC arbitration, the cost is very high and is not affordable. And as a result of that, then they are reluctant to participate. So the other party will have to front the money, and then there will have to be an initial finding by the tribunal with regard to, you know, payment of, you know, funds and so on. Now, although it is new to Sri Lanka, in places such as Hong Kong and Singapore, there has been a lot of recent developments with regard to third-party funding. So my question for you is that if a Sri Lankan company, for example, that had entered into, say, an agreement with a Hong Kong-based multinational, and they have agreed to refer a dispute to arbitration in SIAC, and in that situation, will they be eligible to get third-party funding from funding entities that are operating in Singapore or Hong Kong?
The short answer to that is in principle, yes. third-party funding is authorized in Singapore and in Hong Kong. So in terms of legislation, there would be no statutory bans for parties to an arbitration to resort to third-party funding. But that's an easy answer. The more difficult answer is whether third-party funders looking at the case would find it fundable at all. And that's where third-party funders would run their own due diligence. They would look at the financials of the case. They would look at the strengths and weaknesses of the case and what the chances of success are going to be. And then following that process, they would submit the case to their investment panel, and then the investment panel would then decide whether a funding arrangement would be put in place. And in my experience negotiating with third-party funders, they wouldn't go for a case that would be below $10 million US, because for them, in terms of just the economics of the process, it would be quite difficult. And also for third-party funders, of course, each case is a major investment, because the return can only be potentially after the entire arbitration is completed, the enforcement is completed. So we're looking at a couple of years. So for them to fund the legal fees and the tribunal's expenses, they need to be relatively convinced that the case is fundable on the merits. So they would go through a serious due diligence exercise. And that's where the role of lawyers is very important, because lawyers for the party who is seeking the funding would typically assist the third-party funder with the due diligence, and would in fact provide the initial memorandum or case assessment to third-party funders to even start the process. So I think both for Sri Lankan lawyers, but also for Hong Kong lawyers and Singapore lawyers who are working with parties that need funding in order to pursue their arbitration, it's a very important sort of practice area to find the right funder, maybe a number of them, talk to all of them and see what funding arrangement can be put in place. But in terms of the statutory possibility to have third-party funding for Hong Kong or Singapore seated arbitration, that's a straightforward answer, that both in Hong Kong and Singapore, third-party funding is allowed.
Thank you, Olga. Before I move on to Srilal from our participant, there is a specific question for you. If you can very briefly deal with it, then we can put the questions to Srilal thereafter. So the question is, it says the follow-up question to Olga. Many thanks for the previous answer on the contract-based exit arbitration. In addition to the standards of protection in the contract, will the exit tribunal also be required to apply international law standards such as denial of justice, etc., in appropriate cases?
Yeah, I'll be very happy to hear Professor Shrilal's views on that. I think Professor Sonaraja also wrote on that particular issue as well. My brief take on that is that the tribunal's jurisdiction as to what disputes they might be able to look into would be limited by the wording of the jurisdictional clause in the contract. So it really is important how the dispute resolution clause is drafted in the contract. And for example, if it says, well, any dispute, including for breaches of the universally acknowledged standards of treatment of aliens with respect to this contract, shall be submitted to arbitration, then that would give scope for the tribunal to look into potential breaches of fair and equitable treatment or expropriation. But if the DR clause is drafted in a very narrow way, limiting the tribunal's jurisdiction to very specific breaches of the contract, then I would imagine that would be difficult to bring claims, public international law-based claims, before that tribunal when the contract does not contain such specific protections in the text of the contract itself.
Srilal, could we have your views on that kindly, and thereafter I'll put another question to you.
Yes, 2 points that I might add. First of all, there is no specific clause in a treaty that says that where there is a denial of justice, that tribunals can take cognizance of a denial of justice claim. Now, however, there are denial of justice claims that have been brought forward through specific provisions in a treaty, like the fair and equitable treatment clause, as well as the full protection clause. All those clauses are there. So tribunals have agreed that denial of justice is under international law can be applied to when the claimant has brought it under one of those specific clauses. Again, it goes also one of the areas in which perhaps there can be much more clarification in negotiating an international investment agreement. The answer is yes, but then again, there is no specificity, for example, on denial of justice claims. There is one, of course, Lowen is one of the big cases before, Lowen versus USA was one of the big cases that came under NAFTA, which considered the denial of, clearly a denial of justice claim. So, and there is also Vivendi versus Argentina. Again, there was a resort to local courts for dispute resolution that the investor did not resort to. That claim was considered to be a denial of justice. Although the tribunal went and said, you have to do that to see whether there is a denial of justice before coming to the tribunal. I hope I have answered your question.
Thank you, Srila. Srila, another question is that we spoke about the standards of treatment that should be contained in investment treaties to ensure that there is no discrimination, then there is no uncompensated expropriation, for example, and there is no denial of due process and so on. But for the benefit of our participants, could you explain what are the circumstances in which the violation of a breach of these standards could be excused?
And let me get that. Let me put it in context, perhaps, as I understand it. So the question relates, Asanga, to several areas of treaty, bilateral investment treaty. Sure. Fairly well clarified in terms of expropriation, because in expropriation, the clauses relating to expropriation relate also to both indirect and direct expropriations. So it is fairly expansive in that regard, that the standard international law of prompt, adequate, and effective compensation are still recognized, that it should not be discriminatory, and also due process has to have taken place to make it both, to see whether it is legal or illegal taking. So those are the principles, and those principles have really been taken into account by many tribunals dealing with a whole series of cases I can cite that have taken into account all of these elements. In fact, going from one extreme to another, and one extreme being that it doesn't matter. What is not important is the method by which a state has affected your ownership rights, but the impact of the method on the ownership rights that's relevant. So there is both the direct expropriation and the indirect forms of expropriation that affect property, and those principles that we are fully accustomed to, tribunals have taken into account. Have I answered your question, or
thank you. Yeah. Thank you. And given that we have very little time left, one quick question, and with that I will invite Janaka to wrap up. You spoke of the two cases, SGS versus Pakistan and SGS versus Philippines. Now, these two decisions, which were delivered within a short time span of 14 months, from each other, I think went into two separate directions. And since then, there have been few decisions which either favors one or the other. So as a result of that, at the moment, we are not quite sure what exactly would be the applicable legal position concerning this issue. What is your take on this?
Absolutely, and this is really taking into account a very serious question, because number one is that, as I began my presentation, is that no investment takes place in a vacuum. There's a proliferation of contracts, and I would like to go as far as to say that most of the disputes that have been brought before present-day tribunals arise out of contracts. Expropriation is another matter. How a contract has been expropriated, how assets have been expropriated is another matter. But if you see what in the final analysis, what brought about the dispute is not merely a treaty of the breach, but it arises out of contract. And I can tell you, I was looking at a transaction, and I have been involved in project finance from the other end, and a mining enterprise in Tanzania had 27 different legal contracts, 27 different, which impact on the investment. Any one of them, if it is breached, can scuttle the entire project. So 27. So what I'm trying to say is that an investment should not be viewed in a vacuum or as if nothing. It's extremely complex. And Olga alluded to it as well. I mean, it is so complex that to get a handle on what is going on is really very, very, very critical. And so the point of it is that what I see as the future is that tribunals have skirted the issues. They've almost academically dealt with it, but then went on to resolve a contract dispute in a different manner, went to the fair and equitable treatment standard, having found no breach of a contractual obligation by some means or not, but really have not critically addressed the issue. And if they do in the future, the question will arise of not so much about the forum clause, but the applicable law. And the applicable law in many of, 100% of the cases, is where the contract is executed. In Tanzania, they opted, in this particular project finance case, they've opted for ICC arbitration. So the forum is quite clearly stated there. But if it went to dispute resolution to the ICC, the applicable law is Tanzanian law. So that's the thing. That's the thing. So you cannot really ignore that and say, well, we are going to apply a treaty standard. And this whole thing is very tactical, Asanga. What they are trying to do is to oust the privity of contract by bringing it within a treaty. And extremely good lawyering and very tactical to avoid the constraints of having the dispute resolved in what the investor deems to be a biased system, and that will go against them, and opts for rather the resolution under an international forum. So that's the practicalities of it.
Thank you, Srilal. With that, I will invite Janaka to say a few final words and wrap up today's session. Personally, I would like to thank both of you for accepting my invitation and coming on board. Janaka, please, over to you.
Yes. Thank you, Doctor. And ladies and gentlemen, we have come to the end of our allocated time, unfortunately, for today's webinar. Thank you very much, Professor Srilal, Ms. Baltenko, and Dr. Gunawan, sir, for that enlightening discussion on international investment arbitration, especially on selection of fora and also with regard to your presentation on breach of contracts. I'm sure everybody participating today will agree with me that we learned a lot from you regarding this subject, and that have most certainly opened our eyes on the world of investment arbitration, international investment arbitration aspect. I would sincerely like to thank Professor Srilal, Ms. Olga Boltenko for joining us despite your busy schedules and different time slots. And we do hope to see you both physically maybe in Sri Lanka in one of these days, and do take care. My sincere gratitude also goes to the President of Bar Association, Mr. Kalinga Itathissa, President's Council, and Secretary Rajiv Amarasuriya, and Assistant Secretary Mr. Pasindu Silva for making this today's webinar a success. Ladies and gentlemen, thank you for tuning in, and hope you had an informative learning experience today. Thank you and have a pleasant evening.
Thank you very much.
Thank you.
Thank